Hello, my name is Stephen Minnis and I'm joined today by Professor Horatia Muir. Horatia Muir is co-director of the Global Governance Studies Program at Sciences Po. Professor Muir, welcome.
Thank you very much.
One project that you've been working on in the last few years at Sciences Po is the Private International Law as Global Governance project. I wonder if you could just say something about that and how this project came to be developed.
I think that it stems from the sense that private international law, which was and is a discipline that's extremely stimulating intellectually, isn't fulfilling the role that it could be within the global governance debate from which it is absent. And I have the conviction that this absence is both actually playing a role in creating governance gaps and is also making us miss a lot of potential for using private international law's heritage or methodology in solving a certain number of governance challenges today.
And of course, at this particular time in history, of course, globalization being the great buzzword, these challenges are pressing upon us from every direction, cross-border challenges, whether they be human displacement on a massive scale, climate change, many other challenges. Given the history of private international law's development, in particular its cosmopolitan nature, is it in a sense surprising that this field has, in a way, been absent from the debate over governance of these challenges?
It is indeed surprising, and one would have thought that because private international law deals with private actors and all sorts of cross-border issues, that actually it would interact with the regulation of social spheres that are particularly affected by globalization. And if one thinks that many of the processes that are linked to globalization involve private actors such as multinational corporations, of course, which is the obvious example, but perhaps rating agencies, standard setters, certifiers, etc., it's extremely surprising that private international law hasn't been playing a more prominent role.
And to what part of this challenge is taken by the methodology that private international law has traditionally employed? Is not perhaps reform, but rethinking of methodology part of this project?
Very definitely. I think that to a certain extent, private international law has become imprisoned by two things. One is what has been described as its lack of horizon. In other words, I think the time has come to think about what we expect from law beyond the state. And I think that private international law has to a certain extent been not only lacking in fulfilling a certain vision of the world, but that it's also been imprisoned by its own highly methodological focus. And methodology at a certain point becomes highly technical, and I think, unfortunately, that is what has actually happened to it.
Mm. And at a time when a great deal of de facto power is being exercised by non-state actors, by market actors, the lack of something to say about these developments is perhaps a normative problem, perhaps a policy problem, but something that this methodological question also has to respond to.
Yes, indeed. I mean, obviously one can't reduce the problem to one of methodology. I mean, obviously there are highly important political choices being made every day and in many small details. But it does seem to me that private international law's methodology is determined by a paradigm, in other words, a set of background assumptions that is being constantly challenged today. In other words, sovereignty, state, the rule of law beyond the state. These are concepts that are highly contested today and don't necessarily have any explanatory or normative value, or rather, they probably do, but not as much as they did.
Yes, and if we look for perhaps alternative sources of normative value in this reframing process, one thing that's particularly interesting is the interplay between private international law and human rights.
Absolutely. I think that one of the limits of the pre-global paradigm has been compartments in which different legal disciplines have been closed, let's say. And I think that the arrival of the human rights language has, first of all, shaken up a certain amount of methodology by bringing in proportionality and certain ideas of balancing and a vision behind the law. But of course, human rights is, to a certain extent, only a language. In other words, it may well be that bringing in environmental concerns or gender concerns or concerns about exclusion, these are all equally very, very powerful languages that don't necessarily use the syntax of human rights, but that of course come and upset the compartmented paradigm.
Yes, and if we apply this to just one particular area of activity, the proliferation, the growth of importance of the global supply chains, and perhaps the injustices that occur along the way, this new interpretation, this bringing in of human rights offers perhaps more opportunities to seek redress for those who have suffered in these processes.
Well, very definitely, and we've seen that with the working of the Alien Tort Statute in the United States, which is basically, if one puts it in contemporary language, a statute which allows the bringing of human rights claims to American courts. I think that there again one could frame the problems or the issues that are raised by global production chains in many different languages. Whether they're economic, political, social, one can also highlight all sorts of different problems that arise. Supply chains have environmental aspects. They also have aspects relating to the labor force that they use, which are basically social problems. So, of course, human rights have had an enormous effect. At the same time, as with any sort of universal language, they have their problems too. And it may be that the time has come to reframe a certain number of questions in terms of the structure of the labour market or environment, without necessarily suggesting that individual claims are the answer to everything.
And a big moving part in this changing structure of the global economy that has perhaps in some ways precipitated this reflection on private international law is the increasing relative weight of the large emerging economies, quite apart from Europe and the United States. If we talk about different actors and their interests and how they come into competition, which is something that private international law has long dealt with, this is a development that not just courts, but not just arbitrators, but all the forms of international law seem to be struggling to get to grips with. I
think this is a very interesting question that leads back to methodology and paradigms and the things we've been discussing. Of course, private international law has grown up, like comparative law, as a very Western model. And I think one of the challenges raised by the weight of emerging economies and other worldviews is that we suddenly realize that the tools that we've been using are very, very much centered on values and thought processes and constraints that aren't necessarily shared by a large part of the world. And I think it's very difficult for law in general to come to grips with this situation. When I say law in general, I'm actually talking about international law probably, because I'm talking about things that happen beyond or outside state frontiers. It's an enormous challenge for lawyers everywhere, but it's also a particular challenge for a Western-based vision of the world.
Just finally, at the end of this year in Paris, we'll see the United Nations Climate Change Conference. All the indications are that regardless of how far the progress goes there, it will be insufficient for what the scientists say is necessary to prevent dangerous climate change. Is this an example of how policymakers will have to have regard to not just the public international law of a particular area, like climate change, but what the tools of private international law are and how, perhaps, as this project suggests, they can be reformed and rethought to pursue normative, perhaps even policy goals?
Absolutely. I mean, a rethinking is required of all legal tools, and here private international law is obviously of no exception. If policy goals are refined, then private international tools would normally have to follow. And they would do so in dealing with issues of liability for violation of a certain number of standards, for instance. It's obviously an enormous, very, very tall order for law in general and for a small part of the legal discipline in particular. But I would hope that by integrating a world vision in which the environment has a part, and in understanding that no issue does not have, in this field anyway, does not have a transnational aspect, private international law can help and bring productive tools to the table. Yes.
Horatia, Muir, thank you for joining us.
Thank you very much.